Chair and co-commissioners, this is an application that is being brought by Mr. Brown Mogotsi for the recusal of Matthew Carlson SC, who is the chief evidence leader in the proceedings where Mr. Mogotsi is witness. Now, Chair, what the relief that the applicant seeks is that Advocate Charles Carlson be recused from the matter and an alternative evidence leader be appointed to cross-examine Mr. Mogotsi. The basis of the application rests on the possibility of biasness or impartiality. And this, Chair, stems from
actual bias or actual bias alternatively perceived?
Perceived bias, Chair.
Not actual, but perceived.
Perceived bias.
Thank
yes,
you.
Chair. And the reason for this perceived bias is as a result of events that took place before the Commission on the 9th of March and the 10th of March. Mr. Karim Suleiman came in to bear testimony before the Commission. Now, during the said days when Mr. Suleiman was giving testimony, there was communication between the evidence leader and Mr. Mogotsi, who's the applicant for the recusal. That communication comes in the form of WhatsApps.
I think there is an antecedent question, a legal question, because how we grapple with the events that you referred to depends on what the law is. Because you must first know what the law is, and then you apply the law to what you've referred to as the events, which effectively are facts or factual issues. In your application, you rely on SARFU and other cases. Those cases relate to situations that involve decision makers in whatever form those may manifest. The respondents have taken the point that those cases are irrelevant to a situation like the present, where a decision maker is not involved. And the point made is that the chief evidence leader is not a decision maker. So what law are you relying on? Because the point is correct that the cases that you've referred to in your application relate to decision makers. So are you continuing to rely on those cases? If so, on what basis would they be applicable here?
Chair, I would be inclined to concede that the cases or the case law that was used by the applicant is that of the decision makers and not the parties who partake in the proceedings. But then from that, Chair, I will also submit to the Commission that case law has been brought to the attention of the Commission in the form of an answering affidavit by the respondent. And the cases that are therein mentioned do make provisions for instances where prosecutors and, with this case, an evidence leader may be recused from certain proceedings.
Can you state the principles insofar as you see them, and for us to have an idea of the case you want to make out?
Chair, there is the matter of the DPP of the Western Cape versus Killian. It's a 2007 decision in the Supreme Court of Appeal. The full citation is at 169 in brackets RSA. It's DPP, comma, Western Cape versus Killian, in brackets 2007, SCA 169.
Is it the case, same case cited in footnote 16 of the answering affidavit?
Yes, Co-Commissioner, it is.
Footnote 16 of the answering affidavit on page 70. That's where the citation
That's
is.
footnote.
16 on page 70 of the record.
P70.
And the test there is substantive unfairness.
It's substantive fairness, yes, Commissioner.
Unfairness.
Unfairness, yes.
So that's basically what you'll be relying on. There's also reliance on Porridge versus, is it NDPP, by the respondent.
Yes,
By
Chair.
the respondent. I would assume that the test is the same
Yes, Chair.
in Porridge as well. All right, please continue then. You were dealing with the events.
Maybe just to correct the citation, as we have it here, it's 2008, volume 1, SACR, page 247 SCA. Is that the one you're referring to? Because you've given us a different citation. No,
Commissioner,
let me
according
get
to the
confirmation from
papers,
her.
it reads as 2007 SCA 169.